We're going to talk about motions to suppress here for a moment. Whole books have been written on motions to suppress. So for me to talk about this for 5 minutes, it's not going to be a very deep dive. But let's talk about them. There are 4 basic motions to suppress. Just to let you know what these things are, folks. Well, a motion is asking the court to do something. A motion to continue says, I want to continue the case, right? A motion to suppress says, I don't want certain evidence to be seen by the jury. I want certain evidence to be thrown out. And we call that suppression. And there's 4 basic ones. The first one, the most common motion to suppress, involves an illegal search and seizure. Now, what does that mean? Well, I've got 100 videos probably on illegal searches and seizures. But basically, you have a government entity that violates the 4th Amendment to our Constitution that says we're supposed to be free from unreasonable searches and seizures. And it is unreasonable for the government to do things without a warrant. Per se, if you don't have a warrant to search, that search is probably unreasonable. And there are exceptions to the warrant requirement, but that is the most common motion to suppress you will ever see, is an illegal search and seizure because the cops should have gotten themselves a warrant and didn't get a warrant, or better yet, the warrant that they did get sucked and it's flawed in some way. We sometimes would call that a Frank's motion. It's a motion to suppress, but it's under a Frank's issue, which is a whole nother story. I should probably do a video. I might have done a video on that. Anyway, that's the first motion to suppress. The second motion to suppress is pretty common, is a motion to suppress statements made without Miranda warnings. Now, what does that mean? A lot of people are like, John, I wasn't read my Mirandas. Shouldn't this case be thrown out? Not necessarily, but what I will say is a very popular motion to suppress is the fact that the cops asked you a bunch of questions, you gave them a bunch of answers, they didn't bother to tell you or warn you that, hey, you know, this stuff is going to be used against you. You might want to lawyer up before you go chatting with me about whatever question I'm about to ask you. Those are the Miranda warnings, and we file motions to suppress when the cops are getting information out of you, asking you questions, maybe not even asking questions, but prompting you to say something, and they didn't warn you that whatever you say is going to be used against you. The third motion to suppress that's pretty common is a motion to suppress identification. All that means is, you know what? Somebody is going to come to court and testify that that guy sitting next to John Guidry at the defense table is the guy that stole my car or whatever. Well, that's fine and dandy, but we sometimes move to suppress an identification because it might be too suggestive. And where this really plays a role is in photo lineups. When you get some criminal cases, the cops will come to a witness with a photo lineup of, say, 6 individuals. And let's say that it's, you know, a white guy with glasses, and you got 5 pictures of people that aren't white with glasses, and you've got one guy that is white with glasses. That photo lineup would be suppressed because it is impermissibly suggestive. The cops need to do a better job with their photo lineups to make sure that they're not too suggestive. And if they are, we do a motion to suppress that identification because it was like unfair. Of course the person picked out the white guy with the glasses. He was the only guy out of the 6 that even looked remotely close to what the person described the person as. So, and our fourth motion to suppress deals with evidence and chain of custody. Now, what I mean by that is if the cops claim that they've got a piece of evidence, that's all fine and dandy. Good for you, Mr. Officer. But if this piece of evidence disappears, we don't know where it is, and then it goes to a lab, and then it goes to a police department, and then it goes to the prosecutor, and it goes all over the place, and we can't tell how many people have tampered with this, how many people have touched this, how many people have dealt with this piece of evidence. That's what we call a chain of custody issue, and those chain of custody issues can lead to the fact that the court system can no longer rely on the authenticity of this piece of evidence because we don't know how much tampering or what have you has been done to the evidence. That can lead to the suppression of that evidence. We find this a lot in drug cases, folks, because a lot of drug cases, you got a little baggie and it gets shipped off to FDLE and it sits in some warehouse, and then it goes from the warehouse to the laboratory or whatever, and then the laboratory's testing it and the lab sends it back somewhere, and it goes on. It's like a wild goose chase. If it's not authentic, that chain of custody is not solid, we are going to move to suppress that evidence. So those are 4 pretty common motions to suppress here in Florida. You know, God forbid you get accused of a crime here in Central Florida, because that is where we can help you out. That is where I hope you will call our office. I've been defending these sorts of things for 31 plus years, thousands of cases. I'm sure we can help you out. If not, you can help us out by hitting some various buttons, likes and subscribes, and I don't even know what the buttons are these days, but if you hit the good ones, we would appreciate it. And thanks for watching.